My name is Jason Spitz, Senior Journalist at Self-Managed Super Magazine. The trust deed of an SMSF is a crucial document that defines what a fund can and can't do while you're alive, but also after your passing. So getting the structure right is critically important. Yet people continue to make the same mistakes when setting out their SMSF trust deed. I'm joined today by Insignia Financial Senior Technical Services Manager, Julie Steed, to talk through some of the most common mistakes and bloopers that she's seen in trust deeds. Thanks for joining me today, Julie.
You're welcome. It's great to be here.
Now, Julie, I want to kick off with a question around the a big picture view of trust deed design. It's very important when it comes to designing your trust deed, but what are some of the common design mistakes that people make when it comes to their trust deed?
I think probably the most common ones are people not understanding what their deed actually says. And people just assume that if the law allows something, then their trust deed will allow it. The only thing that we have, to the best of my knowledge, that is incorporated like that is family law. If your trust deed doesn't incorporate the family law provisions, they're deemed to be included. But everything else we need to actually look at the trust deed. It's really common for particularly old trust deeds to be more restrictive than what the law is. So the law has progressed. We now have equalisation of same-sex relationships in Commonwealth law. We now know that same-sex couples can get married legally in Australia. So if your deed specifies and defines eligible beneficiaries, where the law has moved on and progressed, if your deed doesn't, then that person might not be an eligible beneficiary. We also still see a lot of restrictions in relation to pensions, who can actually receive a pension. Limited to particular types of spouses. So that's an important one. And then, lots of other things that we'll cover in relation to death benefits. So the type of nomination that has to be made, or the form that it has to be made in, whether it has to be accepted by the trustee or delivered to the trustee, those sorts of things are things that, people just assume that they can just make up a nomination and it will be acceptable, which often isn't the case.
Can we just briefly cover off just importing stuff, cut and paste stuff from the SIS Act, and maybe some of the concerns, or the SIS Reg, some of the concerns around that?
Yeah, so there's actually two factors there. So the first is Hill versus Zuda was a High Court decision, and it confirmed that self-managed super funds and small APRA funds, so small funds, do not need to use the 3-year lapsing binding nominations in 617, that they can harness the legislative power to direct a trustee what to do. But if the deed does import the provisions of the 3-year lapsing binding nominations, then they have to be complied with. So if you've harnessed that member directed nomination power, you can use that. But if you have imported the 3-year binding nominations, then that's what you're stuck with. So the drafting of the trust deed is really important. And again, making sure that we're using good legal firms that understand what your death benefit nomination preferences are, and that the deed reflects that, is really important.
Now, let's say, for instance, someone says, look, I've got a fairly good will, I've got a fairly good estate plan, so I'm really not that worried about what's going to happen with my SMSF. So I'm not going to wire anything hard into my trust deed. I'm just going to pass it out. And so I'm not going to have a nomination. Or they're maybe not so worried and sort of says, look, if the nomination fails, my estate plan will pick it up. Is the estate plan and the will a good safety net, or is that just opening up another can of worms that should be avoided?
No, I think it depends on every person's personal circumstances. So one of the great things, so if I've got a death benefit dependent, one of the great things about being able to pay the benefit directly from the super fund is that I'm likely to be able to do it much more quickly than I can to get it into the estate and then back out of the estate. If it goes into the estate, I need to have a really well-drafted will to make sure I'm not messing up the tax consequences if there are any, commingled non-tax dependents in there. So make sure I've got my superannuation proceeds quarantined in the will so they can be dealt with. I'm not sure what it's like where you are at the moment, Jason, but in South Australia, the probate courts are so backed up, it's taking months to actually get probate. So I know that I could liquidate my SMSF and pay a death benefit well before I've even, my application for probate's being assessed, let alone, granted and paid into the estate. So it's definitely pros and cons. What if my partner would benefit from having a death benefit pension? So if I paid it into the estate, I can't get it back into super. Now we've got a situation where clients under 75 could recontribute back to super, but in small chunks. So if I've got $1 million death benefit sitting there and it's advantageous for my partner to take it as a pension, directing it to my estate will negate, that potential great tax planning strategy.
I want to move on. A lot of stuff we've looked at has related to setting up your trust deed and setting up your nominations inside your trust deed to deal with what happens after you pass away. But you can set up a trust deed in such a way to restrict things, and maybe intentionally so, for while you're still alive. And the first one I want to look at is who can be a member. What are some of the problems that people have done that you've seen there, that people have done with their trust deed?
So again, if I'm getting a trust deed today from a reputable superannuation SMSF specialist lawyer, I wouldn't expect too many problems. The main place where we get problems is if I'm not using an SMSF specialist lawyer, or if I'm using a deed that is old. So a classic with membership will be the member must be gainfully employed on a full-time or part-time basis, because pre-2000, I can't even remember, you had to be gainfully employed, and we had pre-2006, we had compulsory cashing when you get to 65 and aren't working, or at 70 in all instances. So if I've got a pre-2006 deed, it's quite likely to have imported those conditions and possibly copied it from an old corporate fund trust deed. So if I'm not gainfully employed, my membership ceases. If I turn 65 and I'm not working, my benefit is compulsorily cashed. So another one that we see a lot is if you lose capacity, you cease to be a member. Well, that's great if you're in a retail fund, or in olden days in a corporate fund where the trustee of the fund will just pick up your benefit and pay it, on the grounds of disability. But it's useless in an SMSF, because if you're not a member, you're not meeting the definition, and then you've got tax consequences.
I think one of the big upshots is that read your deed, have a good look at it, understand it, make sure you get it from a reputable SMSF trust deed supplier. And also, if you've got an old one, review it. Not necessarily replace it, but make sure it's fit for purpose. Thanks, Julie, for your time. Much appreciated.
Super. Thanks, Jason.
Cheers.